So now we looked at criminal justice policy in its various aspects. So we have discussed three primary constituents of criminal justice policy or system: police, courts, and prisons. We have looked at different approaches or models like due process model and crime control model. Then we have looked at various theories regarding punishments such as rehabilitation, reductivism, and retributivism. Is our system based on Islamic law or British common law? The answer to both these questions is negative. Common law is based on judgment of the courts. The British don't have a constitution, they have an ancient history, they have conventions, they have laws, and these are the convention and laws are the basis of the common law. Pakistan instead has a constitution, and laws and judgments have to follow the supreme law, which is the constitution. So any court or law cannot be against the constitution. So this is the primary difference from the British common law. So is our justice system based on Islamic law? The answer is no. There are only few laws that are based on Islam or based on Islamic or Muslim history. For example, Hadood laws, Hadood and Zakat and Ushr ordinances. Even these are, their link with Islam is there, but are they perfectly according to Islamic laws and principles? That is questionable. For example, Zakat is collected on bank accounts, and anything which is present in a bank account on a specific day of the year, that is the first Ramadan, then the Zakat is deducted from that. But the main primary issue with this concept is that in the Islamic concept of Zakat, you have to have the assets on which Zakat is to be paid for at least 1 year with you. In this case, in Pakistan's Zakat rules and laws, you don't have to have those assets for 1 year. Even if you have for 1 day, the Zakat is deducted. And if you take Zakat, if you take that money out for that 1 day, you can save yourself from Zakat. So Zakat ordinance is not actually according to Islam. Hadood ordinances are promulgated, but they have not been implemented and limited in a few cases. Questions have also been raised about these ordinances. Then the implementation of Zakat of Islamic laws have been hampered because of the fact that there are differences in fiqhs. For example, when Zakat ordinance was implemented, there was a large demonstration by the Al-Tashi or Shias or Shiites because according to their fiqh, they are not to give their Zakat to the state. They give their Zakat to their ulama. And eventually, the Zakat law was give them the exemption that their Zakat will not be deducted. Similarly, there are other issues with the fiqh because fiqh is mostly coming from medieval times, and when the interpretations were made by men, and mostly they were against women. So we need more interpretations of Quran and Sunnah done by women so that they are more equally regarded. Then there is the issue of federation and provinces. Pakistan is a federation. So in many federations, the constituents of the federation, such as states or provinces, have different laws. So if you go to the US, each of the 50 states has its own law that is applicable there. In case of Pakistan, there are no separate laws. All the provinces, as well as Islamabad or other federal territories, are governed by the colonial penal code. So even the Pakistan law is not there. Pakistan has only adopted the penal code which was there in the British colonial times. and it's still applicable all over Pakistan. So it is the Pakistan Penal Code 1860 and Code of Criminal Procedure 1898. So if you look at the dates of these laws, the PPC is more than 150-year-old, and the criminal course of CCP is more than 120 years, around more than 120 years old. And they are still being applicable in not only Pakistan, but also India and Bangladesh. This penal code of 1860 was prepared by First Law Commission, and it was chaired by Lord Macaulay. We may be against Lord Macaulay and many of his statements which were racist, but it stems. So if these laws are still applicable in Pakistan, this means that either they were very brilliant, or else we are very lazy, that even when the laws are not so good, we are still using them. We are not changing it. We can argue that they were racist, cruel, and autocratic, but brilliant, or we can argue that PPC and other British colonial laws are still there because they have become a part of our culture. If Mughal penal system had been allowed to continue, it would have been there, and we would have been developing that system rather than following the British colonial system. The argument is important because in case of Nepal, for example, it was not colonized, and it used its own penal code, centuries old penal code until recently, and it has no problem with that. Thank you.